Welcoming our next panel, number 2 for the morning, a new day at the SEC, the impact of changes in leadership, priorities, and organization, and what comes next. Moderating our panel is Rachel Copenhaver, partner at Vedder Price in Chicago. We have Amy Stahl Cotter, partner at Lewitas, Hyman, PC in Chicago. She previously served for 20 years in the SEC Chicago Regional Office. She was assistant director as well as senior trial counsel. We have Steve Malina, who's a partner at Greenberg, Traurig in Chicago and previously served in the SEC Chicago Regional Office. Keith Constance, managing director for FTI in their risk and investigations practice in Chicago, and he spent 6 years as a senior accountant in the SEC's Division of Enforcement. And finally, we have Jose Lopez, a partner at Perkins Coie in Chicago, and he previously served as a senior enforcement attorney at the SEC.
Thanks, Rebecca. So we have a full agenda, so I'm going to dive into it, but we're planning on talking about changes in structure, practice, operation, sprinkle in some enforcement priorities as well. And so starting maybe with you, Amy, given that you were at the SEC earlier this year, for the audience, can you please just describe the office structure, practice in Chicago, and maybe talk a little bit about how the different structure has maybe impacted some of the cases while you were there?
Sure. So before I start, though, I want to give a shout out to all our SEC colleagues in Chicago and around the nation for their service and for persisting in the face of hard times. So I want to say that out loud. Keith joins me in that sentiment, and I'm sure everybody does. So the structural changes that have happened so far are not, I don't think, going to dramatically alter the landscape of enforcement. They have appointed deputies across the country to be right below the director of enforcement and his and her staff. But that's essentially just another layer. It doesn't change what the regional offices will do, what the enforcement staff in DC will do. With the staffing changes after people leaving, there's going to be a lot of triaging going on, and those folks, I think, will be carrying out the goals of the enforcement director as that triaging starts in the short term.
Keith, you were recently at the SEC as well on the as an accountant. So any observations or insights you can share having just recently been over there?
Yeah, I think, being through a few transitions and I think 5 or 6 different enforcement directors, what happens at the staff doesn't change that much. I mean, I think, speaking personally, what matters most in the regions and particularly in Chicago are the leaders that are in the office in Chicago. And, there are fantastic leaders here in the Chicago regional office. The staff has a lot of latitude to kind of approach cases how they'd like. So I don't think that changes much. Certainly the priorities can inform what cases are opened and what comes out of case generation committees. But in terms of the day-to-day, I don't think it changes a whole lot.
And I think when you were both at the SEC, Amy and Keith, were you in the office 5 days a week? Was that starting to get implemented?
So after COVID, we had a voluntary return period. Some folks were back, some weren't. I was in the office a lot just because that was my preference. And but it made no difference to production whether people were in the office or not. We had such great tools that had developed that they gave us to use that the hybrid model really worked. Then they started bringing people back. Again, it was late in the spring, so it didn't. I think folks who have had longer commutes or more challenging, personal life issues, it was a very big negative, but everyone tried to make it work the best that they could. And again, as Keith said, the leadership in Chicago was doing everything they could to make it work for people.
Maybe turning things over to the defense bar, and maybe starting with you, Steve. What changes, if any, have you observed the past few months in terms of your interactions with the SEC in light of some of the restructuring that was just talked about?
Candidly, I haven't discerned any significant changes, at least relative to the new matters, the matters that came to me this year as opposed to matters that may have commenced under the prior administration. It's always attorney-specific for me. Some of the government folks are easier to work with than others. Some of them are more flexible. Some of them will, entertain conversations about what they're looking at, what they're interested in. But candidly, I haven't discerned any material changes yet.
And what about you, Jose? Has kind of what we've just talked
Yep.
about impacted how you, interact with?
Not surprising, my view is a little bit different. Look, here's the reality. We all work with the SEC office here. We had deep, long relationships, and for us to see, the demise of our beloved MRO and then CRO, and to see that transition, where we have a significant major financial market here in Chicago, it was difficult for us, right? We've now seen a shift in power that moves from the local office where we can go in, leverage our relationships. Again, we don't ever get special treatment, but we know our colleagues, we work with them, and we want to be able to tell our clients, we can call them, here's how things generally operate. So for us now, I think on the defense bar for the next, call it 6 to 12 months, we need to figure out and learn now what is going to be the new process. How do we navigate it? Do we start with the local level? Do we bypass that and just go directly to headquarters or Antonia directly? And so that piece is going to be a little bit difficult in terms of figuring out. Some of it will rely on our SEC colleagues that are still there. My experience with them has been they've been very frank, like you're just going to need to go and do X, Y, or Z. I think the information coming out of the commission is they're looking to do more robust meetings and giving us an opportunity to do that. But for me personally, it's a big loss to see that. It's unfortunate, but hopefully it comes back. We'll see. But I would have loved to still had a big regional office here in this market. And so I think it's disappointing from my perspective.
Defense lawyers are definitely going to miss more cases.
I could answer that question for you if you want.
I'd love it.
Which is just always start with the staff, because even if you need to get approvals at higher levels, they are relying on the staff for all of the information that they get about those cases. They, the independence of decision-making in the Chicago office, which still exists, by the way, it's not dead, right? It may not ultimately lie at the level that it used to, but in the time I was there, even recently, I have never seen, and maybe this will change, right? If it gets to that stage, they're typically listening to what the staff has to say. Now maybe there are resource issues that will make a different decision. Everything they are learning about your case is from the staff. So you may have to hit higher levels in decision-making, but you're never gonna be able to skip that relationship stage. It's gonna help you. So, for what that's worth.
I appreciate that. And we've been talking about Chicago and regional office and maybe taking it, broader, higher up leadership level to switch topics a little. So, there is a new SEC enforcement director, Meg Ryan, I think effective earlier this month, September 2nd. And obviously it's only been a few weeks since Director Ryan's been at the SEC. And maybe starting with you, Amy, and then going to Keith, what insights can be shared regarding Director Ryan, either based on what we know about her background or just based on, since both of you have been at the SEC during this transition period when new leadership is stepping in, what that might look like?
Sure. Well, first of all, I have a practice tip, which is apparently Director Ryan would like to retain her honorific, so she is Judge Ryan, so you could get some brownie points that way.
Great pro tip.
Yeah. I would say, again, I've been gone only since March, but I have been, again, like everyone on this panel, through a lot of leadership changes in enforcement, and enforcement doesn't stop. I go back to Arthur Levitt, right, which is crazy, but it's just the priorities change. This might be a little bit more of a time where those seem more dramatic or extreme, but the staff is not stopping, the staff is working. there may be changes in what the priorities are, but, and that's around the country, right? The news and all of the information that's coming out is very high, it's about the leadership. The staff is working every day on their cases, and they are affected by all this the news media stuff, but they're not stopping their work. So I don't know if Keith has anything else.
Well, I can say, when Gerbier was there, I think I spoke to him once. So again, just to kind of reiterate this fact, the staff continues to do what they're going to do. I do think that there's maybe some more top-down willingness to have those discussions early on. And I can certainly say from my perspective, I found that helpful. Most cases, even if they're big, complicated accounting cases, there's one accountant, one attorney. We just don't have the resources to really do a fulsome investigation. So we appreciate it. I appreciated it when I was there, when defense counsel would really dig into the facts, hire experts, and come in and present and say, here's the issue. Because we don't want to waste our time on cases. I didn't want to waste my time on cases that didn't have anything. So I do think that that's clearly something that Judge Ryan is interested in. I was at a conference last week, I think many people here were there, where there was an SEC panelist that gave a little bit of insight into her work style, but one thing they said was her first Wells meeting, she took defense counsel by surprise a little bit with the level of detail for questions, and so I think she is encouraging the staff to have those conversations earlier. But it depends on the case, it depends on the facts and circumstances. You're not going to get a discussion with every case, so it just kind of depends.
I think we should expect with her judicial and her military background that she is going to implement Chair Atkins' priorities. It's a new day, at the SEC. Don't expect to see the rulemaking by enforcement type cases, the very creative cases. He said he wants to go after the people that lie, cheat, and steal, sort of the bread and butter fraud cases, manipulation cases, insider trading cases. They've indicated, they're looking at individuals and individual culpability, and I think we can expect Judge Ryan to steer the enforcement program in that direction.
And I would just add, I think, as an observation, I think this is right, that this is the first time where the former enforcement person stayed at the commission after a new person was appointed. So I think a lot of that, I hope a lot of that was by design to help Her Honor in navigating the securities processes, the laws, the culture, the fit. I'm not sure if that was the reason, but it didn't go unnoticed that Sam did not depart and is still there, and we hope is helping with the transition.
So I think we might still be in early days with Judge Ryan, but there have been some process changes and at least some public speeches regarding certain things that have changed in the meantime since the beginning of 2025 at least. And so one of those that I wanted to touch upon today is the change in the formal order process. And what has happened, just to kind of, for the audience, is rescission of the delegation of authority to the Director of Enforcement, and that going to the Commission. And so maybe starting with you, Amy, I'm sure that was already in place while you were at the SEC, but what did that mean in terms of the day-to-day operation and opening of new matters?
As a practical matter, it just slows everything down, right? You're going to see, there's going to be a longer lead time. You'll also see staff coming to you with more informal requests. Again, that's where maybe defense presentations and experts come in. You get a better understanding on the front end of what you're facing, especially in the complex cases. But from a staff perspective, that's just another step that we have to take, and we'll take it. And in most cases, right, there's not going to be an issue. The Commission has always had the authority to, even when the authority was delegated, to request that a formal order be heard at a Commission meeting. And even in the last administration, that began to happen frequently on like the cyber cases, the crypto cases. So that's always been their right. They just, in the past, have not really exercised it unless they have an issue that is of particular concern in a specific case. So it's just going to create, for the defense bar, a longer lead time in investigations. But maybe that will, again, the staff is looking for the most efficient way to do their jobs. They don't get paid by the hour, so they want to do it efficiently and not waste their time. So maybe the pivot will be to trying to get people in early if people will come in and talk about what's going on.
Can I ask Amy a question? Amy, do you expect that the staff will be more careful now in terms of what cases they want to get a formal order on, knowing that it's going to a higher level right out of the box?
Well, I would say no, but only in that, like, there's this misperception that the staff is out there before, like, willy-nilly opening investigation. Everything that the staff does is driven from the director level, the AD level on down. No one is, I mean, there are case generation committees that talk about issues and think about how could we examine this area and see if there is enforcement actions that should be taken. The staff has never operated independently. So that's a misconception that I think is out there. The formal order process, again, if you have an investigation that needs to be brought and you need subpoena authority to do it, it's just a procedural step now.
Sure.
Like I said, it's just going to be a lag time. I don't think anyone's going to be careful because you wouldn't take that step if you didn't have justifiable reason to do it in the first place, whether it sat with the director of enforcement or not. You have to set forth the facts that establish why you're pursuing this as a formal investigation. So that's always been the case. Now this is just it's a procedural hurdle, which will slow things down for people.
And I think, Keith, we were talking a little bit about this earlier this morning, but I could imagine a scenario which has happened before, prior to this change in the process, is something could just exist in the informal inquiry investigation phase, and a formal order is never sought, never opened, and the matter resolves itself. So kind of what's your perspective on, is that something we're going to see more of potentially?
Yeah, I think it's a lot of still the same. It's just that the approval requirement moves up the chain a little bit. But when I was at the SEC, if we wanted to kick the tires on something, we'd send a voluntary request, which, as I'm sure most people in this room know, tend to be a little bit more forthcoming in what the issues are, because you're trying to get to the root of the issue to figure out whether this is something that you need to go get a formal order for. But there are still instances where you're going to, if your clients just get a subpoena out of the blue, a broad subpoena, that staff probably knows something right at that point. So I think that process has always existed. It's just a little bit in a change in terms of when you go get the formal order.
Can I add something there too, which is that's also true for cases that get brought and are resolved in settlement. So I've had many investigations where I never issued a formal order, especially for regulated entities, somewhere where we could get the information without a subpoena. And if the defense lawyers are amenable and they see there's an issue there, it's a way to efficiently work out a resolution. But in those scenarios, you can still go and get a formal order if you need it, right? If people don't want to cooperate, they're going to get their formal orders. It will just take longer.
Let me add just a little bit of a wrinkle. You imagine the scenario, you get a call, voluntary request. You have to debate whether you decide to comply with that or not. Given the change in this process, you have to seriously consider when you provide notice to any of your carriers. If you comply with the voluntary request, arguably you're on notice, but that does not trigger your policy. Generally, the law is that the subpoena, you have to look at the individual policies, review them, but by and large, most of them will not trigger until you get a subpoena. So there are many instances where a voluntary request comes in, you deny it, and wait for the subpoena. In this case, I don't know if that's going to happen. And so you have to really think about and navigate whether you respond to the voluntary request, put the carrier on notice, and then decide what you're going to do in that interim, right? Clients are expecting their insurance carriers to cover the fees and costs, but if you're not triggering that policy, there's a tension there. And so give some serious consideration as to whether you're going to be able to comply with that voluntary request, or perhaps fast track the staff or the others that are involved to see if you can get a subpoena issued so that you can then submit it to your carrier.
I have a matter now that it's not out of Chicago, that I was surprised when I asked the staff to say, yeah, no formal order. And then you have this conversation to pick up on what Amy said with the client, and the client asks, well, if it's voluntary, why don't I just say no? And that's a pretty common, thought process and an understandable one. But then to pick up on what you just said, the answer is, I think they really want this information. We can tell them, go pound sand, but then they'll go get the formal order. And would you rather have a formal subpoena from the SEC or do this informally? So that's kind of the conversations that I think we're going to have more of with our clients as the formal order process becomes more cumbersome, and maybe the staff tries more often than they otherwise would to go the voluntary route.
And on the process point, one other item that has come up, and there's been discussion about this, including at SEC Speaks, is the importance of having a robust Wells process. And for example, when Deputy Director Antonia Epps was speaking, she explained that the Commission believes that a robust Wells process is important for due process, fairness, and transparency, and suggested that there would be, at least an increased likelihood, or at least a willingness to consider, if you make a meeting, a request for having a Wells meeting, that you might be able to get members of the Home Office or other people above the staff attorneys on that case. So, Amy, in terms of when you were at the SEC, what observations can you share in terms of either the frequency of Wells meetings? Did they change in any way?
So I would say the frequency has varied over the time period. They were never off the table, even in past administrations. Again, I think it was a different view of deference to the staff's interpretation, maybe, of the facts, or did people feel that they were being heard? In scenarios where a Wells meeting is not going, where the facts are very clear, I think in the past they were less likely to grant those, just because if everyone could come, or do a remote meeting and talk for an hour, and the director wouldn't have learned anything new. So the real purpose of those meetings is to advocate for your clients, to bring a new perspective to the facts. If you have a novel legal or factual issue, to bring those to the attention of the director. But I will say, in the times that I've been a part of it and I've done it, all of those issues are already brought up to the director, but it's your chance to make a pitch. So I don't think they were ever off the table. I think if they're doing them now, I still would be surprised if they're doing them in every case where they're requested. But maybe they'll set up a structure where that's a regular part of the enforcement process, and they'll bang through them, right? I do think they want people to, that was always our job. We serve the public. We want to make sure we're doing the right thing. So it just was a question, I think, of different views of whether it facilitated the process or whether it didn't add additional facts that the director didn't already know from staff.
So Jose and Steve, are you seeing an increased Wells process opportunities? And if not, how does what we're hearing about their, having a robust Wells process available, how is that changing how you're working with your clients to strategize on whether or not to ask for a meeting? And if you're asking for a meeting, who are you asking those types of meetings with?
This falls in the bucket of be careful what you ask for, because we've always asked to talk. We went to a meeting recently. There were 15 lawyers from the SEC, all prepared, all ready to ask us questions, pulled out specific documents, specific emails, wanting to know what is this person going to say? What do you think that person's going to say? So we wanted that. We want a robust process. We want to know what the SEC is thinking. We have had multiple requests to go back several times, which is a little unusual, but they would call and say, well, now we have more questions, or we have a different question. And so it is very, very robust. We welcome it. We want that dialogue and that interaction because as Amy said, we want to inform the staff and perhaps cure a misunderstanding or show a different document, or you're reading this one out of context, here's why it makes sense. And I will say that our experience is that the staff is genuinely interested in understanding the case, understanding the facts, pushing back hard on some of our arguments, and just simply saying we just don't buy it or we don't agree. And that's okay, right? We're not always going to agree. But to walk into a room with 15 people ready to come after you and your client is daunting. So you have to be ready. On the one hand, it's very good news for us because we have to be ready to engage them on all potential topics, because you have somebody from the Division of Finance or the accounting or enforcement. I mean, there was a huge group of people here that were all interested in their particular areas of expertise. So we needed to be ready for that. And if we're not, we ask to come back, and they've been amenable to that. But I think you are going to see an increase in the number of folks that are participating and want to get to the bottom of issues that they're really considering and are focused on.
Yeah, to sort of pick up on the be careful, what you ask for. Clients frequently tell us, well, can't we go to the head of enforcement, or can't we go to that person's boss? They're wrong. And the be careful what you ask for is if you get that, just making the ask puts the people that you're dealing with on the case on the defensive. Now they know that they're going to have to defend their case to their bosses. And they, as Amy said, they already have. Everything is fully vetted. But when the process is over, you're going to go back to dealing with the counsel that you dealt with before. If there's someone senior in that office, if there's someone who has been there for a long time that's respected in that office, don't expect some paradigm shift when you attempt to go above them. But that said, I think the signaling is fantastic. Mm-hmm. This, we will meet with you, or we will at least entertain a request, is a shift from the signaling from the prior head of enforcement, and a significant one. And in the right cases, to echo Jose's comments, it is a good thing if you can get a sit down, with a group, even if there's going to be 15 people. Those are the people you're going to have to deal with down the line. And they're going to be the decision makers in how to frame an enforcement case if they actually file one. But be careful what you ask for.
Can I add something to that, Steve, which is I would recommend that you're engaging in that process with the staff level people to the final document, argument, and then go, right?
Right.
Because it may inform the staff when they're confronting you at the meeting, but if you bring new information that you haven't shared with the staff, that's going to look it's not going to look well for people. So I would recommend that you share all that up front.
Well, just picking up on that point, we always ask, who's going to be there? What do you want us to address?
Right.
Any particular emails? And generally, it's, no, come in and do your presentation and we'll ask questions. So we go in a little bit blind, and then, that's why we have to be nimble and ready. But we always do try to ask for that information. Generally, we don't get it, right?
Well, if you asked me, I would have told you.
And that's why we all loved you.
I know.
So with the time that we've got left, I want to make sure we talk about enforcement priorities and some of the shifts there. And so one of the things I wanted to talk about first in that vein is a new cross-border task force that was announced earlier this month, and in the theme of what is old is new again.
Right.
Keith, maybe can you describe that task force a little bit for the audience? And I think just notably, given your accounting background, that task force announcement does talk about a focus on gatekeepers, auditors, underwriters, along those lines.
Yeah, I kind of key in on the gatekeeper piece, but this isn't necessarily anything new. I guess a renewed focus, but has always been a focus, I think. Back in the 2010s, I think there was a similar cross-border task force when My friend Howard Scheck was the chief accountant that looked at Chinese reverse mergers, Chinese companies that didn't really have legitimate business merging into U.S. companies and looking at the auditors that, help those companies access the U.S. capital markets. So it's something very similar to that. But I think it's been something that, has always been a focus, particularly of, the enforcement accountants group is amazing. They have a lot of former auditors, former accountants that are really focused on looking at gatekeepers. I think one other thing I heard at the conference last week is this idea that, looking at gatekeepers, problematic gatekeepers, particularly auditors, is a great way, for lack of a better term, for the SEC to get the best bang for their buck because it can be pervasive. And, shout out to Taryn here, who was on the BF Borgers case. I mean, that's a great example of a auditor that signed 1,500, reviews or audits over a 2.5-year time period that dealt with 350 plus companies. So, something like that is a great case for the SEC to bring because it just is pervasive. So it'll be interesting to see how they approach that. I could imagine some sort of initiative that looks at these companies that are, particularly helping foreign filers access U.S. capital markets.
And I couldn't help but, state the obvious. It's the last full week of September. Typically, this is the time of year where your email box is getting inundated with press releases and litigation releases, right? And so maybe starting with, with you, Jose, what are you observing in terms of the trends, in terms of the number of matters we're seeing or not seeing, and kind of what are your thoughts on that in light of the fact that we are very much still in a transition period?
Yeah, I mean, I think is picking up on what Amy said earlier, a lot of things are slowing down. I think there's just still some uncertainty, I think, among the staff as to what do we do? What is the right path? Am I going to offend somebody if I investigate a particular case or if I reach out to somebody? So I think there's been just a general chilling effect on doing the day-to-day job, right? What are we going to do? How are we going to do it? Because nobody wants to run afoul of the administration. And so I think slowly but surely we'll see some things start to trickle out. But so far, I think most of us have observed that there's just been a bit of a slowdown in terms of the cases that they're bringing or the announcements. And Steve and I were talking earlier about, in at least some cases where there's been a statement that a litigation release is going to be put out, and it just hasn't happened or hasn't hit yet. So, Steve, I don't know if you want to pick up on that, but we will see some announcements, I'm sure, but I think that will pick up in the next 6 to 12 months, call it, but at least for the first part of the year, we haven't really seen a robust review of cases that have come out.
Yeah, I mean, case numbers are definitely down. There's no doubt about that. Staff is definitely down. There's fewer of them to investigate. There's fewer of them to bring cases. And, you have the overhanging, there's a new sheriff in town with a new set of priorities, and that's going to shift how they do things. Some feel that there was a rush to get cases in under the end of the prior administration, and that may have goosed up those cases and left fewer cases, that we're seeing now, cognizant that the cases you see filed today likely started as investigations a year ago or 2 years ago, and it takes time, to germinate to the enforcement case. But yeah, I think there's less business for the defense bar right now. That might change as the new administration implements its new focus on the bread and butter cases. Maybe we'll start seeing more of the traditional fraud cases, insider trading cases, market manipulation, and maybe some of those numbers will pick up. But as a practical matter, the SEC staff is just not, it doesn't have the footprint that it did before, and that's going to necessarily impact, how fast they bring cases and how many cases they can bring.
Yeah, and if you're keeping up with current events, if the government shuts down, it's being reported that may be a reason to further cut staff at all of the agencies, and if that includes the SEC, we may see further reductions. So hopefully that doesn't occur, but stay tuned and see what happens with that. But with the consolidation and some of the elimination, we've, as Steve said, we've just seen a slowdown. So that is going to be, I think, the foreseeable future until we have a little bit more guidance on the priorities and how they're going to be implemented and how many staff are available to do that.
And while there might be fewer cases, at least coming out, maybe we can spend some time on the types of cases that are being brought or the types of cases we expect might continue, particularly now that we have Director Ryan, Honorable Ryan, involved at the SEC now. So a lot of what has been said at conferences or public engagements is the sort of back to basics, bread and butter, including focus on retail investors, insider trading, accounting fraud. So maybe starting with you, Amy, what types of enforcement actions have happened, and in light of this current transition under Honorable Ryan, and Judge Ryan, should we expect?
Well, I think around the commission, the bread and butter cases have always been there. Accounting fraud can happen in niche markets, or it can happen anywhere. So maybe you're going to see a slowdown in cases where this administration doesn't want enforcement to happen. But I still think the majority of SEC actions are going to be brought. To Jose's point about staffing, a lot of people in my position, the assistant directors who are leading groups and getting cases through the finish line are gone now. So even if there's a fair amount of staff, there's going to be triaging of not only in line with priorities, but just in line with resources. So any registrant is always fair game, right? And those will always continue because they've subjected themselves to the jurisdiction of the SEC, whatever the type of case it is. So along with the market participants, kind of fraud, accounting fraud, insider trading has always been there. Market manipulation has always been there. So I think it's just kind of the fringes where this administration has a different view of what should be done. You'll see those fade away, at least in the short term.
I can kind of add on to from the accountant's perspective, what we're seeing at FTI is more focus on accounting issues of private funds, investment advisors that advise private funds, particularly around valuation. That's things that I worked on quite a bit when I was at the SEC. That's not to say that public company accounting fraud is not still a focus. I view those as bread and butter as well. But certainly I think the focus on private funds and sort of that direct investor harm is there.
The statements about focusing more on individual culpability should also be interesting to see how that plays out and what that means in the corporate boardroom for the people that sign, the disclosures, CFOs, COOs. Do they need to be even more careful now because they're signaling we're going to focus in on the folks that we think could have stopped this or prevented this or should have known about it?
Well, the interesting thing there might be also, do they ever bring an action against the company?
Right.
Or are they only going to go after the individuals now? Because it was always a kind of a package. If the actors of the company caused the company to do things and the company did something, right? But now they might be like, we're just going to go after the individuals.
Well, it's always an interesting debate, right? Go after the company and who are you hurting? Impose some huge civil penalty, and are you hurting the individuals who did the wrongdoing, or are you hurting the shareholders of the company?
Right.
One thing to also consider, despite what the priorities have been, there's just going to be a group of cases where the companies on their own issue restatements or acknowledge some change in accounting policy or financial reporting that typically would trigger an SEC case. And maybe if they're not focused on the company instead of the individuals, there certainly will be the plaintiff's bar that will file those class actions either in Delaware or in the various districts where they're located. So I think the civil litigation part of it might not go away, even if the commission decides not to go after the companies or focus on individuals instead. You're still going to have the plaintiff's bar who's going to hold those companies accountable for what they've done. So that aspect should not change.
the only twist on that is the plaintiff's bar now is probably less likely to wait and see what happens on the government side, because the plaintiff's bar loves to hop onto government, actions as well, and they may not be waiting for that now.
And I think, Steve, you mentioned, some aspect of corporate liability and corporate remedies. So I wanted to open it up to the group from there. What observations are we seeing in terms of the types of remedies that are being sought by the SEC, where they're being sought, and do we expect any repositioning of either the size of the penalties or the types of relief that might be sought by the SEC?
I would say absolutely, yes. They're going to go down. They're going to go way down. That's just my prediction.
And do you think that that's tied to maybe a focus on individual liability versus corporate liability in terms of, where some of that money might best reside?
I think it's partially that, but, Commissioner Peirce, Commissioner Ueda have publicly said for a long time that, they don't always think that corporate penalty, and Chairman Atkins definitely has said that, right? In the past and now, that's not the remedy that should be the be-all, end-all. Whether you agree with that or not is a different question.
Yeah, I mean, this debate was really raging during the off-channel communication settlements, where you're seeing just tens of millions of dollars of fines by companies who'd rather pay than fight, and to that point, that there were some dissents in that approach to enforcement. I don't think we're going to see a lot of that going forward.
So obviously monetary relief is just one piece of the puzzle. So are we thinking, are we expecting imposition of compliance consultants to still be in vogue? Are we, there's been for a while prior to, 2025, there would be instances if you had accounting fraud cases where you might have a springing independence compliance consultant if you didn't mediate certain things. So are we expecting to see maybe more creative approaches to relief that aren't necessarily big dollar signs?
Well, that certainly is going to drop, right? I think they've already been signaling that they're not going to be seeking independent consultants to come in the way they did in the past, and that should be a huge relief to at least to our clients, because that is a burdensome, expensive remedy that sometimes you had no choice, and apparently the independent consultant is going to be demanded more judiciously going forward. I think that's a positive development.
And to that point, Stephen, I think remediation is a word that keeps coming up. If you can show that you've taken concrete steps to remediate an issue as a company, that's clearly going to inform whatever the remedy is. So I think that's an important piece to consider.
I agree with Keith on the remediation part. That's going to get you a long way to not needing something, even if in a situation where the staff is advocating for it. But the other piece of that is, we talk about creativity and creative solutions, but the reality is we need a basis, or I'm not we anymore, the SEC, I'm still new to this. They need a basis to recommend something that the commission adopt, and that then becomes something that is a potential for any other case, right, of the same genre, the same fact patterns, and so they're very careful about that, right? So whereas between private parties, you might be able to come to a really creative agreement, I don't expect they're going to become more creative now. I think you're just going to see the absence, like Steve's point, the absence of those additional steps being taken.
We've always counseled clients, stop the bleeding. If there's a lapse in your surveillance system and that caused a whole bunch of transactions to go through unsurveilled and they're bad, we've always done that. But now more than ever, if it's fixed when you're having this discussion with the staff, there is no reason to bring in an independent consultant and let that camel's nose under the tent to review everything. All the more get it fixed, get your house cleaned up, get it fixed before we have this conversation with the staff about how to resolve this matter.
Right, and I would say before, or maybe in different administrations, even if that was the case, staff would still look and potentially have a case to bring, whereas I think now there's a good chance, I don't have a crystal ball, but you would maybe walk away from that.
Right.
Just given, at least in the short term, given the staffing challenges and the triaging that's going on.
That makes sense.
Well, we are ending it basically right on time here. So I want to, thank the panel. Thank you, Steve. Thank you for Jose. Thank you, Amy. And thank you, Keith, for joining us this morning. I think we're going to a break next, and then we'll be back with accounting fraud, I think. So just to plug in, I think we've sort of talked about some of the topics that will be more fulsomely described in a lot of the other panels later today, including the insider trading panel.
Thank you, Rachel.
Yeah.
Thank you.
Thank you.
Thank you.
Thank you, everyone.